Welcome back to the Brody Windsor Group podcast, where we go beyond the transaction to bring you trusted advice for every stage of homeownership. Today, we're talking about something that too many families wait far too long to deal with: planning for the day when a parent or loved one can no longer make decisions on their own. If you're a homeowner, especially a senior or the adult child of aging parents, this episode is for you. Because the truth is, selling the family home isn't just a financial decision. It's also deeply emotional and often tangled with legal procedures that most people never think about until it's too late. That's why I'm joined by notary Nada Chalaby. Unlike many notaries who focus on real estate transactions, Nada has carved out a unique niche, helping families navigate protective mandates, tutorships, and homologations, procedures that protect vulnerable people but can cause costly delays if they're not handled properly in advance. Together, we'll break down what these terms actually mean, the risks of waiting, and the peace of mind that comes with planning ahead. Most importantly, she'll share real-life examples that highlight the human side of these decisions. Thanks for pressing play. You're listening to the Brody Windsor Group on Real Estate, the podcast for homeowners seeking guidance and support on everything related to owning a home. This includes much more than just buying or selling. We've got you covered for everything from mortgages and financing to home maintenance tips, renovation and design advice, and of course, the latest insights and analysis on what's happening in our local communities. Good morning, Nada. It's great to have you on the show.
Hi, thank you, Scott, for having me.
I'm really looking forward to this conversation with you. But before we dive into the nuts and bolts of the topics we're here to discuss, I wanted to get a little bit of a backstory from you because your practice is a little bit unique. You know, most notaries that we come across, they handle real estate transactions, and you decided to go into a different stream and specialize in wills, mandates, homologations. I want you to tell us a little bit about how that came about.
Yeah, sure. So I started off as a real estate notary. So it's been 15 years I'm a notary. I started off only doing real estate transactions, working notaries' offices, lawyers' offices. And for me, it was too transactional. You know, you're a number, go on, and you just, pass on to the next person. But whereas homologations and tutorships, it's more of a human touch, and that's what I liked. So I just stumbled upon a file and I started doing it. It was a homologation and I really loved it. Just getting close to the family, you become a person they can trust. So I liked having that human aspect of it.
Oh, I can really identify with that because it's very similar to our business and how we saw a difference between the volume-based transactional real estate industry and really being more of a long-term trusted advisor and working with clients over the long term throughout their entire journey of homeownership. And it sounds like there's a lot of parallels there in terms of what attracted you, which is relationships with families and helping them manage oftentimes a very stressful.
Exactly. It's a difficult time for them. So I like that closeness with them, and they can really rely on me. They text me, so we have that kind of relationship, which I like.
Now, most people are familiar with a lot of these legal terms like wills, mandates of incapacity. But I was hoping you could explain them each a little bit more detail so that people understand, because what really is the difference between them and how they're used and in what instances?
Okay, so a will is when you pass away, right? So it's only for that, because I've had some questions. Oh, I have a will, it's fine, if I'm incapacitated. No, it's completely different. A will is only when you pass away and you basically want to leave who you choose who you want to leave your things to, who will be the legal guardian of your minor kids, who will manage the money of your minor kids until they're 18. So that's what constitutes a will. A power of attorney is when you want someone to take care of your affairs, your finances, when you're of sound mind.
So give me an example of someone, at what stage in life or what age do you usually see people coming to get their wills done? And in what instances would a power of attorney be applied?
So a will, as soon as they have young kids, they absolutely want to do a will, because who's going to take care of their kids, if they pass away, who's going to manage that money if they pass away. So absolutely, a lot of people do it when their kids are young. Second would be a divorce, because you don't want your ex to have, to receive your estate. And sometimes also when they're older, they want to make modifications to their will, such as who will be the liquidator, taking care of the estate. So that would be the stages I see mostly.
Good.
Yeah. And the power of attorney is basically when you're of sound mind. Let's say you're on vacation for 2 months. Let's say you're hospitalized for 2 months. Who will be the one going to the bank and signing your documents for you, for example?
Right. Okay. And so in what instances do you usually see that with families? Is it sort of
The power of attorney?
power of attorney? It can be all age groups?
All age groups, but most, like, people 30, 40, they don't really use it. But I would say after that, they would want it if you're a snowbird, for example, you're out of the country for 6 months and you want, for example, your daughter to go to the bank for you, then they will be able to do that.
Okay.
Or if you're hospitalized for a few months, you get older, and I that's what I see most.
Okay, so you're seeing mostly with people as they age, older populations.
Yeah.
Now, the next thing is the mandate. So
Right.
explain the difference between the mandate and the power of attorney.
So the mandate of protection, so it used to be called mandate in case of incapacity, but now the legal term is mandate of protection. And it's used when someone is incapacitated. Only when it's incapacitated does it come into effect. So you name in advance a legal representative who will manage your affairs, your assets for you, and not only that, your medical decisions. So the power of attorney is different from that because it's only your assets and your finances. The mandate of protection, when you become incapacitated, there's a part where the legal representative manages the assets, and another one, the medical decisions.
And what's the definition of incapacitated? Is it mental, cognitive incapacity?
It affects your mental capacities. So I see a lot Alzheimer's, dementia. It can be a coma, but I rarely see this. But it's mostly what I see is Alzheimer's, dementia, and so on.
Okay. And then you mentioned tutorship as well. What exactly is a tutorship, and when does that come into play?
So a tutorship is when there's no mandate of protection. You become incapacitated. So it's a legal measure that ensures the protection of the incapacitated person and manages the administration of that of the incapacitated person. So it's really to ensure a protection of the patrimony of that person.
So we covered what a mandate of protection means. When would a mandate of protection need to be homologated? Because we run into that all the time in the real estate business. Maybe you could expand on that and tell us a little bit about the difference between having a mandate of protection and when it needs to be homologated by the courts.
Yes. So homologation only means to put the mandate of protection into effect. So you confirm the incapacity with a medical assessment done by a doctor and a psychosocial assessment done by a social worker. And you also confirm who the mandatory will be and their powers. So when is it supposed to be homologated? As soon as there's incapacity. So if someone needs to sell a home, then that's when usually, as you can see probably, that's when usually it needs to, people wake up and they say, oh, my father's incapacitated and we have to sell the home. And it has to be homologated because the notary doing that sale will not accept it if it's not homologated.
Right. And I think this is where a lot of confusion sets in, and we've run into this many times ourselves, when people were not aware, they said, I've got a mandate of protection. And they thought that was all they needed. It was fine. And so then go to sell the parents' home and arrive at the notary for the signing and discover, oh no, the notary is not going to sign the deed of sale because the parent is incapacitated, not able to make decisions on their own. Therefore, they need that mandate homologated, correct?
Exactly.
So this can cause a lot of problems.
Yeah, and I've seen it also where they don't have access to the bank accounts. They want to move money, they want to transfer funds, and the bank doesn't want to accept it because the person is incapacitated. They can't make decisions for themselves, so it needs to be homologated.
Right, and so what would you advise people to do, and when is the right time to start that process, and how long would it usually take?
So as soon as someone's incapacitated, because you never know when you want to sell the home of that person, when you want to go to the bank and transfer funds, even filing the income tax, you need to be able to do that, right? So as soon as there's an incapacity, I would say start doing the medical assessment. That's the first step, is doing the medical assessment by a doctor and the psychosocial assessment by the social worker.
Okay. Now, can this be any doctor, or does it need to be somebody who specializes in this?
No, I mean, it's usually the family doctor or a geriatric doctor.
Okay.
So that's the most I see in my practice.
And then I'm assuming there are also social workers who specialize in this type of thing, like you are specializing on the notarial side.
Yeah.
Like Mandy,
yeah,
who referred you to us, as it so happens. And so maybe talk about who are all the professionals you would advise people to have on that advisory team.
So a family doctor, a social worker like Mandy, a real estate broker. So when it gets to the point where they need to sell their home, that's it.
How about when you talked about financial issues, right? In managing investments and assets that are not just real estate assets. Well, maybe the wealth management advisor,
a right person at the bank, I would say.
The right person.
They need to be aware.
Accountants, lawyers.
Accountants as well for the estate planning.
Exactly.
Yeah.
Okay. So when you've got a homologated mandated protection, what's the role of the mandatory? Meaning in most cases, it's the children of the individual who's been incapacitated.
Right.
What do they have to go through?
So they have to manage the person's patrimony. They have to ensure that it's well protected, and they have to make any medical decisions for them as well. So that's the main things. And they also have to render accounts on a yearly basis to a verifier. So since November 2022, there's been a new law where we need to name a verifier in the mandate of protection. It can be a family member, it can be a friend. So someone who will verify what the mandatory is doing on a yearly basis. So what are the expenses? What are the income, the investments? So they need to verify what the mandatory is doing on a yearly basis. Why? Because unfortunately, there's been cases of financial abuses in the past. And that's why since November 2022, the government put in place that part.
So this is basically another layer of protection.
Exactly, for the patrimony of the person who's incapacitated.
Right.
And 60 days after the homologation has been done and finished with, they have to give an inventory to that verifier. So the inventory of the incapacitated person's patrimony, so expenses, income. So it's, like you said, an extra protection for the patrimony of the person.
There was another misconception I run into quite often too, is sometimes I see, husband and wife where the deed of sale is only in the husband's name. Mm-hmm. And they did it for maybe a variety of different reasons. And there was a separation of property, and there was an agreement between the husband and the wife. However, when it comes to a situation like we're discussing, where there is incapacity in one of the spouses, some people mistakenly believe, I think, that they were fine because the home was not in the spouse's name.
Right.
Maybe talk a little bit about that and the protection that's implemented to protect that spouse.
So the house, the main residence, is part of the family patrimony. So if it's only under one of the spouse's name, the other one has to sign off when there's a sale of the property.
Right.
So therefore,
they have to give their permission
they are
aware that the house has been sold with their knowledge.
Exactly. Yeah, because it's part of the family patrimony.
Right. And then again, of course, if they're incapacitated and can't make those decisions on their own, then
the mandate needs to be
homologated.
Yeah.
Okay. Now, you mentioned to us in our discussions before the topic of tutorship. And I don't think many people understand exactly what that is and in what cases it would be needed. So maybe describe that for us.
So a tutorship is a legal measure to ensure the person's patrimony is well protected. And it's only in the case where there's no mandate of protection. So if you didn't choose in advance who will be your legal representative, then the law will choose it for you, right?
Okay.
So it's, again, an extra measure of protection for the person's patrimony.
It sounds complicated. I take it that's something you want to avoid. Am I correct?
You do want to avoid it because a tutorship is a bit more complicated than a homologation of a mandate of protection. Why? Because the mandate of protection, you chose who your legal representative will be, their powers as well. But now a tutorship, you didn't do a mandate of protection. You didn't choose who your legal representative will be. So now the law has that extra measure of protection and has to basically choose who will be your legal representative.
Is this what's called the public curator?
So the public curator is a government entity who protects vulnerable people, such as someone who has an incapacity. The public curator comes into place first when there's no one wants to be your legal representative. You have no family, you have no friends, no one wants to do it. Then the public curator will be your tutor, okay? If you do have family and friends, that's perfect. What happens is they have to get together. So one of my roles, one of the steps of a tutorship is to establish a tutorship council. So it has to be 3 members, so it can be family or friends, and 2 substitutes in case the 3 members can no longer do it. So the tutorship council is there to ensure that the tutor is managing in a good way the patrimony of the persons who is incapacitated.
Okay. Now, how long would these processes take? So let's talk about, first of all, the mandate of protection. You can get that done at a notary who is specialized in doing that. If you then need it to be homologated once somebody is incapacitated, how long would that process take? You mentioned doctor's assessment, social worker's assessment, and then it goes back to you and you file this all with the courts.
Right.
How long can that usually take?
It really depends. So the doctor, how long will it take him to do the medical assessment? Depends. But I've seen it pretty fast, like a month. And then you have the social worker. Again, private social workers will do it faster than public social workers because unfortunately it's not their priority, the public social workers, and it can take months and months and months. Whereas the social worker in the private can do it in a month.
So what should somebody expect in terms of?
So then it comes back to me.
Yeah.
I have to do a lot of steps. I have to do a mandate search to confirm that, in fact, it's the last mandate, or in fact, there's no mandate. So then we do a tutorship.
Right.
I have to go meet the person in person. If there's a tutorship, we have to meet all the family to establish a tutorship council and decide who will be the 3 members, who will be the 2 substitutes, who will be the tutor, who will be the replacement of the tutor.
Wow.
So that's an extra step when you do a tutorship. And I have to send off a lot of paperwork to the court. So when all of this is done, it takes 6 months for the court to render a judgment. Unfortunately, it's been like this for years. They're very backed up. So until someone analyzes your file, it takes 6 months to render a judgment.
Okay. So the bottom line here is don't wait for a crisis to occur where all of a sudden something happens to mom or dad and you're sort of left scrambling to figure out what we're going to do, because we've had these situations as well where, mom or dad has to go into a long-term care facility, which are very costly these days. Sometimes there's no space at the public facility, which are obviously less expensive, and they need to go into a private care facility, which are extremely expensive, but they need access to mom or dad's investments accounts, or they need to sell the house in order to help pay for this. Well, they can't do one without the other. And now you're stuck behind the 8 ball with a delay of 6 months to a year, realistically, before you can actually do anything.
Yeah, exactly. So that's why people have to go in and start doing that process right away.
Right. Have you seen examples of this where people have left it to the last minute, and what was the result of that?
I've seen it, unfortunately, where they don't have access to their accounts and they have to pay the bills at the CHSLD. So now they're just stuck, and they might just not be at the CHSLD anymore because they don't have access to the accounts. They can't pay the bills. They cannot file income tax. So the persons who's incapacitated have lost their benefits, such as dental plan. So it's very unfortunate. So then they come and they're like, I need to do this as fast as I can. I act as fast as I can, but then the courts, I have to leave it, under the hands of the court. They have to take 6 months to actually render a judgment.
Right. So that's just adds a huge other layer of stress to an already stressful situation in terms, and again, most adult children these days, you're busy. It's a sandwich generation, right? We're busy with our own young families, our jobs, and then trying to be a caregiver to our aging parents. I mean, I've gone through this with my own family, and we saw that with my dad and my mom being the primary caregiver. Fortunately, we were aware of those steps to take and got those things done. But even then, it's still an emotionally trying time.
Yeah, for sure. And it is stressful because, and I've seen it mostly in tutorships, because some people say, well, there's no family members. I can't find those 5 people who will be, who will be in the tutorship council. So again, tutorship is a bit more stressful than a homologation of a mandate, because you have to then choose who's going to be the tutor, who's going to be a tutor replacement, who will be the members of the tutorship council.
Right.
So,
but sometimes you can have joint mandataries, right? If you're
I've seen two mandataries.
Yeah, like 2 siblings can say, well, we'll share the burden because it is a lot of work.
Yeah.
And a lot of effort to maintain that, especially with the new laws coming into effect where you need to submit things to a verifier.
Right.
So there are a lot of things you need to know. What kind of support is available to families to help them navigate through that process and help, let's say, a mandatory
So the public curator is very helpful, actually. So they have a public register where they have all the tutorships, who is the legal representative of that person. They have also all the homologations, because as a notary, I not only have to submit everything to the court, I have to submit everything to the public curator. So they're aware of who is the legal representative to who. So they do support the tutors. They send out information. They are there. You can call. They're there to answer your questions. So I would say the public curator is very helpful.
In the example where somebody has not planned in advance and done a mandate and had it homologated, and it needs to go to tutorship, what are some things that people need to be aware of if they're going to sell a house and liquidate some assets?
Yeah. So the tutorship, because again, they want to ensure that the person's patrimony is well protected. And when you didn't choose who will be your legal representative, then the court has to approve anything that's over $40,000. So a home usually is more than $40,000. Any investments, so the court has to approve. So on top of doing a tutorship, when the tutorship's done, you have to do an extra step, and that's getting the court to approve your sale of the property because it's more than $40,000.
So that exact example happened to me. I helped a single mom with 2 kids purchase a house just after the pandemic, and she had cancer, was in remission. And then after moving in, it was probably 2 months after moving in, and I called to check in and see how things were going, and found out that the cancer had returned. She had to go back for treatments, and she ended up passing away within a matter of weeks. And I was in contact with her family and then discovered that she had no will. And so the brother was going through probably this tutorship process to try and get control over her accounts, because she wasn't able to pay. Nobody was able to get access to the accounts to pay the mortgage, to pay the property taxes.
Right.
And so obviously we couldn't sell the property. And what happened was a year and a half went by, still hadn't got the court's approval. And then we get notification from the city that for unpaid taxes, the property is going to be going up for auction. I mean, just a complete nightmare. And luckily, the bank agreed to pay the taxes, and we were able to salvage that. And it finally got right, and we were able to sell the property. But the steps that the poor family had to go through in order to sell the property and pay off the debts, and then have something left over for the kids was.
So that's when someone would pass away without a will.
Yeah.
So you also need a tutorship counsel. So here in Quebec, you do, when someone passes away without a will and the minors inherit more than $40,000, then you have to do a tutorship counsel where same, 3 members, 2 substitutes, and they have to approve along with the court as well anything that's over $40,000.
Okay, so the bottom line takeaway and recommendation here is
do a mandate and do a will.
Do a will.
Do a mandate and do a will, because or else you're gonna have to, if there's a home to sell, you need an extra step, and that's having the court to approve it as well.
And don't be afraid to have these conversations with your parents or your kids earlier, before it gets to a point where you're losing your cognitive abilities to manage things on your own.
Yeah.
Right? Because a lot of people, they just don't want to talk about it. It's uncomfortable. Yeah. They push it under the rug.
Happen to me, and
it's not going to happen to me. Exactly. Until it's too late, and then you're scrambling around trying to prepare the house at the same time as figuring out what the steps are for the mandate and homologation. And sometimes if you've left it too late and you don't have the mandate, then you have to go to tutorship, and that's not fun.
And that's extra steps. And more stress, I feel, for your family, because then they have to choose, who will be the tutor, who will be the members, and so on.
Right. You have a special certification that you needed to do in order to do homologation.
Yes.
Not every notary has this.
No. So you have to be accredited by the Chambre des Notaires. And it's you basically have to take a few hours. It's like 15-20 hours, and you become accredited for homologations and for tutorships, for example.
But there may be some notaries out there who primarily their business is real estate transactions.
Right, exactly.
But they also did the certification course way back when, and they say they can do it as well. But I've heard that, again, it's probably the same with anything. If you're not a specialist, if you're not in this every day and understand how to navigate the process through the courts, have a stable of trusted collaborators like the social workers like Mandy, that you have the doctors that you can refer people to, it's probably going to be more difficult and take much longer. Would you agree?
Yeah, I would agree, because a lot of notaries now do real estate, as you mentioned, and it becomes a big volume, and they usually don't have the bandwidth to take on a lot of homologations and tutorships. So sometimes, and Mandy had mentioned this also to me, it just sits at their desks for a few months, and time is of essence. It needs to be done. So and you do also have to know what are the new rules of the court and so on. And now I know the court clerks who approve the homologations or the tutorships. So it does take someone who knows how to navigate this.
And this is what I love about what you've done, is you've niched down. And I remember asking you this question: is there enough business without doing any real estate transactions? And your answer was,
of course, there's a lot of demand. And also Mandy, that's what the social worker,
that's her specialty as well.
Specialty, that's all she does. Assessments for this.
Exactly. So when you have somebody whose expertise lies in that area, right, you're going to get things, you're going to get the right advice, you're going to get the right information at the right time, and that's going to make the process.
And it's going to be done
sooner.
Sooner. Yeah.
Quicker. Okay, I really like this because, again, this ties in with our whole philosophy, right? It's work with the right professionals, work with people who are specialists in that specific area, who can really advise you and guide you through it, and start early. Don't wait till the last minute. Just like in real estate, we say, don't start a month before you plan to put your home on the market. Start a year, 2 years, 3 years even before, and start getting ready, start planning for it. And this is another example of great advice that people need to be aware of. So I want to thank you again very much for sharing your insights and expertise with us. And if anybody wants more information and would like to get in touch with you, how can they do that?
They can call me 514-952-6339, or go to my website, nadachalaby.com.
Awesome. Thanks very much.
Thank you.
I hope today's conversation with Nada opened your eyes to just how important it is to prepare before a crisis happens. If you haven't already done so, you should definitely check out episode 15, where Sean sat down with social worker Mandy Novak-Leonard to discuss strategies for managing this complex and emotional journey. If there's one takeaway, it's this: waiting too long can leave families overwhelmed and facing unnecessary legal costs. But with the right guidance, a trusted notary, a social worker, and an advisory team like ours, you can protect your loved ones and make transitions much smoother. If you'd like to learn more about Nada's services, visit her website at nadachalaby.com. And if you're thinking about selling your family home or preparing for the next chapter, you'll also find helpful resources on our website, including guides on incapacity and supporting aging parents. Visit brodywindsor.com. Thanks for listening, and remember, when it comes to life's biggest transitions, proper planning and the right advisors make all the difference.